Okay, we're on the record in case number 9722, Phase 2, in the matter of the application of Chesapeake Utilities Corporation, Sandpiper Energy, Inc., and Elkton Gas Company for a general increase in their natural gas rates and for approval of certain other changes to their natural gas tariffs. Start with appearances, starting with the company.
Good morning, Your Honor. Brian Quinn on behalf of the companies.
Good morning. OPC,
Good morning, Your Honor. Ryan Shu for OPC.
staff.
Good morning, Your Honor. Ruthie Herman on behalf of staff. Also my colleagues Harrison Scher and Michael Dean on behalf of staff.
Good morning. Mr. Quinn, looks like there's some preliminary exhibits anyway that you might want to enter into evidence. The only thing I noted was in your list that you circulated, I didn't see the certificates of publication for the pre-hearing conference.
Yes, Your Honor. I don't think your notice required certificates of publication for the Phase 2 pre-hearing. If I remember correctly, I was going to bring that up, but...
If it didn't, then you don't need to enter them into evidence.
Okay.
So, starting with exhibit...
Would you like me to go through the list, Your Honor?
Why don't you go ahead and mark everything?
Okay. Yeah. And Your Honor, Brian Quinn on behalf of the companies, I believe we agreed to start over again in this Phase 2 with exhibit numbers. That's why I started with exhibit number 1. And it begins with Phase 2 joint applicants, exhibit number 1, which is the joint application, and Appendix 1, which contains the articles of incorporation for the 3 companies. That was filed on November 7th, 2024, as mail log 313427.
So marked as exhibit 1. Yeah, I have JAPH21, but that's
Gotcha.
Whichever, it's fine.
JHP2, Exhibit 2 would be Appendix 2 to the joint application, which consists of Christopher Redd's direct testimony and 2 exhibits, also filed on November 7th, 2024 at mail log 313427.
Okay, JAP2 will be marked.
JAP2-3 is Appendix 3 to the joint application, consists of the direct testimony of Joey Ball and Matt Evergnam and 2 exhibits, again filed on November 7th, 2024 at mail log 313427.
JAP23 will be marked.
Thank you, Your Honor. JAP24, which is Appendix 4 to the joint application, Phase 2. It consists of Kim Estrada's direct testimony filed on November 7th, 2024, again at mail log 313427.
So marked.
JAP25, Appendix 5 to the joint application in Phase 2, consists of the direct testimony of John Taylor and exhibits, filed on November 7th, 2024, at 313427 mail log number.
So marked.
JAP26, which is Appendix 6 to the joint application Phase 2, direct testimony of Svetlana Atoyan, again filed on November 7th, 2024 at mail log 313427.
So marked.
JAP2 number 7 would be the certificates of publication regarding the February 11th, 2025 virtual public comment session, filed on February 6th, 2025 at mail log 315511.
So marked.
JAP2 number 8, which is the rebuttal testimony of Kim Estrada, filed on February 7th, 2025 at mail log 315571.
So marked.
JAP2 number 9, rebuttal testimony of Jonah Ball and Matt Evergnam, jointly filed on February 7th, 2025, again at mail log 315571.
So marked.
Thank you, Your Honor. JAP2 number 10, rebuttal testimony of Svetlana Atoyan, Atoyan's her last name, February 7th, 2025, mail log 315571.
So marked.
JAP2 number 11, rebuttal testimony of John Taylor, filed on February 7th, 2025, at mail log 315571.
So marked.
Thank you, Your Honor. JAP2 number 12, which consists of the joint applicant's letter in response to the customer comments received during the customer comment hearing. The letter was filed February 19th, 2025 at mail log 316053.
So marked.
JAP2 number 13, it's the Phase 2 joint motion for approval of unanimous settlement agreement, filed on February 28th at mail log 316307.
So marked.
JAP2 number 14, Chris read testimony in support of the settlement, again filed on February 28th, 2025, mail log 316351.
So marked.
JAP2 number 15, testimony in support of settlement of Matt Evergnam, filed on February 28th, 2025 at 316351 mail log.
So marked.
JAP2 number 16, testimony in support of settlement of Kim Estrada, filed on February 28th, 2025, 316351 mail log.
So marked.
JAP2 number 17, testimony in support of settlement of John Taylor, filed on February 28th, 2025, again at mail log 316351.
So marked.
And then finally, Your Honor, JAP2 number 18, testimony in support of settlement of Svetlana Atoyan, filed on February 28th, 2025 at mail log 316351.
So marked. So I think, based on the status, that the parties don't have any objections, or tell me if I'm wrong, you have any objections to JAP2 1 through 13.
Staff has no objections. Thank you.
Okay. So JAP2-1 through 13 will be entered into the record.
Thank you, Your Honor.
We'll hold off on 14 through 18
Okay.
for now. All right, Mr. Red is available.
Yes, ma'am. Chris. Your Honor, the company's called Christopher Red to the stand.
Please raise your right hand. Do you solemnly affirm under penalties of perjury that the statements made in this matter stand are the truth, the whole truth, and nothing but the truth?
Yes, I do.
A little louder.
Oh, yes.
Into the microphone.
I didn't hear it, but is the mic on?
Yes.
Okay. Could you please state your name, spell your first and last name, and give us your business address?
Chris Redd, CHRISREDD, 500 Energy Lane, Dover, Delaware.
Mr. Red, do you have your testimony in front of you?
Yes, I
that you
do.
filed in this case? Do you have your direct testimony
Yes.
that you filed in Phase 2 on November 7th, 2024?
Yes.
And does that testimony consist of 17 pages of question and answer?
Yes.
Okay. And, Your Honor, he has his direct testimony in front of him, which has already been moved into the record in Phase 2. And, Mr. Red, do you have your rebuttal testimony in front of you as well?
Yes, I do.
Okay, and your rebuttal testimony has been marked as JAP2 number 14, which hasn't been entered into the record
That's
yet.
not rebuttal. He didn't file rebuttal.
No.
Oh, you didn't?
Settlement.
Oh, settlement, that's right, that's right. Your Honor, that's all the testimony Mr. Red has filed. I apologize.
Okay. Is your witness ready for?
The witness is
Questions?
available for cross-examination.
Mr. Red, you joined CUC in 2004, correct?
Yes.
And the Maryland Division last increased its base rates in 2006, some 18 years ago, is that correct?
That's correct.
And Sandpiper filed its last rate case in 2015, correct?
That's correct.
And that rate case ultimately resulted in no rate change in the first year, followed by a multi-year rate plan whereby Sandpiper lowered distribution rates annually over the next 5 years as it converted its distribution system from propane to natural gas. Isn't that correct?
That's correct.
Of the three companies, Elkton Gas last increased its rates most recently, correct?
That is correct.
And that was in 2019.
Yes. I'm sorry.
Or you can pull the mic to you. You don't have to lean forward. So Elkton Gas, of the three companies, Elkton Gas is the one that last had its rates increased most recently?
Yes.
So can you explain why is it then that Elkton Gas, whose rates were adjusted most recently, needs a large increase again at this time, more so than the other two companies whose rates were not adjusted recently?
Well, there's been a lot of cost increases over the last 5 years. I mean, and a lot of it to do with just the economy and everything of that nature. There's obviously a smaller class of quantity of customers in there, so the impacts of those costs going up impacts them kind of more so than the other units.
That's the only reason that Elkton Gas is going to have a significant rate increase where the other two aren't, is because of cost increases?
I mean, the cost increases, and again, the proportionate share of customers, those customers take the burden of the increases.
So you believe that the other two companies are getting the same increase, but they have more customers to spread it over?
I mean, there's multiple factors, and also the investment in those areas per se. I mean, again, there's been increases across all three of them for reliability items and everything of that nature as well.
Is more investment being made in the Elkton Gas service territory than the other two?
I'd have to go back and check.
Are you generally familiar with Elkton Gas's prior rate case decided in 2019?
Vaguely. I wasn't associated with that rate case.
Would you believe me if I told you that in that case the proposed order was issued on January 7th of 2019?
Sounds reasonable.
And the company filed tariffs pursuant to that proposed order on January 17th of 2019, which requested an effective date of February 11th of 2019. Would that sound reasonable to you?
Sounds reasonable.
And then after that, the proposed order became a final order on February 7th of 2019. And the matter was considered at the February 20th, 2019 administrative meeting. And that ended up being the new effective date for new rates in that case, almost 2 weeks after the final order. Would you believe that?
Yes.
Are you familiar with case number 9632 in 2020? That's the case pursuant to which the Commission approved the acquisition of Chesapeake Utilities Corporation, their acquisition of Elkton Gas.
Yes, I'm aware of it.
Are you aware that in doing so, the Commission specifically noted, quote, customers are further protected from reliability, quality of service, and quality of customer service by the applicant's agreements with regard to maintaining employee levels and maintaining the location of Elkton Gas's headquarters in Cecil County. Thus, the settlement operates to mitigate the risk of harm to Elkton Gas customers from the acquisition, end quote. You familiar with that part of the order?
Mm-hmm.
Where is Elkton Gas's headquarters now?
It's still in Cecil County.
Where is it located?
Downtown with High Street.
Is that where the headquarters of the new consolidated company will be located?
The consolidated company, there are offices still going to be in Cecil County, yes. But
But not the headquarters of the new company.
The headquarters for the new company, I guess, is still based out of the Maryland office.
You don't sound sure. The new company is proposed to be Chesapeake Utilities of Maryland, is that
Yes.
correct?
It is a Maryland-based company. It will be Elkton's transitioning its name to that.
But you're not certain where the main office for that company will be.
Well, most of the services are still housed out of the the Dover office that are supplying services back into the business units.
Dover, Delaware.
Mm-hmm.
So the application cites a number of prior commission decisions. Notably, 5 years after the commission approved rate consolidation between Frederick Gas and MNG, the commission approved WGL's request to merge Frederick Gas into WGL and transfer Frederick Gas's franchises to WGL. You familiar with the application language?
Yes.
So in that case, the commission said that to effectuate the merger and related transactions, Frederick Gas and WGL must obtain the prior authorization of the commission, and the commission must find that the applicant's proposal is consistent with the public convenience and necessity. Does that language sound familiar to you?
Yes.
What factors are relevant to whether a transaction is consistent with the public convenience and necessity?
Again, that the customers will not be harmed, the service is the same or better.
Anything else?
Those are the ones I recall.
So I was told you have your direct in front of you.
Yes.
I'm on page 5.
Okay.
How does payment for CUC provided corporate services work now?
Excuse me?
Payment for CUC provided corporate services?
Mm-hmm.
How does that work with the 3 individual companies?
Many of the employees that are working on the different business units directly charge time into the different units, and then others are allocated to the units based on number of customers and so forth.
So each of the 3 companies pays some amount to CUC based on those shared services?
Yes.
And the new entity that's proposed to be formed will still pay CUC as that happens now?
Correct.
In the footnote on page 5, you talk about how Chesapeake organized and operated the Worcester County assets under a wholly owned subsidiary, Sandpiper. Is the Worcester County service territory somewhat different than your other service territories, in that a number of the residences are seasonal use?
There is some seasonal customers in Worcester County, but there is a lot of year-round residents, especially in several of the towns that we serve.
Do you know why Sandpiper has 3 existing residential rate classes?
It was what was filed at the time.
Do you know
Yeah,
why?
I don't.
What about the town of Elkton? When you're describing your service territories on page 6, you talk about agriculture, farming, and poultry production at line 16. But the town of Elkton is sort of a dense town, not rural, correct?
That's correct.
So there are differences in cost to serve between customers in Elkton than in your rural counties?
I mean, many of our towns, I mean, no different than Salisbury or anything like that. We have densely populated areas, Ocean City.
Okay. Is your testimony that each of the companies serve customers in close proximity and in similar rural service territories in which certain industries predominate, including agriculture, farming, and poultry production. That's your testimony,
That is
correct?
correct.
Okay. But then now it's also your testimony that there are also towns throughout your service territories?
Yes.
What can you tell me about the conversion from propane to natural gas in Sandpiper's service territory?
When we purchased the assets and for the Sandpiper company, it was all propane served. Now the majority of it is now been converted over to natural gas.
There's still some propane?
Very little.
So starting on the bottom of page 8, you were asked to summarize the reasons the transfer of the franchises is consistent with the public convenience and necessity.
Yes.
And you told me the factors that you think are relevant are if the customers are not harmed and service stays the same or gets better.
Mm-hmm.
So then, starting on page 9, you talk about the reasons why you think the transfer of the franchises is consistent with the public convenience and necessity. How does realigning the three companies under a common, well-known, and allegedly trusted brand benefit customers?
I think right now, again, in adjacent areas, there can be some confusion between the different names. For instance, in Cecil County, we have both companies operating in Cecil County. So when you're operating with in close proximity, even with emergency officials, the clarity of having a single name would make it easier. Again, for our customers, clarifying all the different tariffs that we have when they see one company and stuff and consolidating it into a single tariff, it'll be easier for them to understand how corporation having multiple service territories would have a standard tariff versus having multiple different tariffs.
But is there any issue with the clarity of the individual tariffs now?
Looking at it on an individual basis, there's not. But again, when you see Chesapeake, you see different company names within it. So again, within the county and stuff of that nature, this will help clarify some of the things and create a better customer experience.
Is there any claim that any of the three companies are not being transparent with customers?
No.
If a customer has a home in one territory and a business in another territory, won't they still experience different rate classifications under the proposed single tariff?
Yeah, but a lot of the other fees and other components of the tariff would be aligned.
But if they have a home in one territory and a business in another, they'll still experience different rates for their
That's correct.
business than their home. Is this any different than a residential customer of BGE who owns a business in Pepco's service territory?
That is correct.
That there's no difference?
I mean, but again, the other tariff provisions would be dissimilar, where in this case they would be aligned.
Is there any other benefit to spreading costs over a larger base of customers than protecting from rate shock?
I mean, anytime you have a cost increases, being able to spread it over a larger customer base would be easier.
So we spoke briefly about payments to CUC for CUC-provided services, but there are no intercompany billings, are there? Or
No,
intra?
not between the-
Sorry, intra.
No, not between those companies.
So the main confusion now seems to be emergency services with the two companies in Cecil County.
Well, and again, we're adjacent in other areas as well. I mean, the next town over, you know, and stuff of that nature in Worcester County, but in Wycomico and stuff, they're different, even though they're adjoining counties. Again, you have that same.
Worcester right now is Sandpiper.
Yep.
So customers are confused because Sandpiper is a subsidiary of Chesapeake? I'm not understanding the source of the confusion. If somebody was a Sandpiper customer, they're confused. Why?
No, I mean, again, when you're responding to different areas, emergency responders, I guess, yes, from a customer standpoint, they are separate.
And you testified that consolidation will provide enhancements. What are the enhancements the consolidation will provide?
Which page are you on? Sorry.
I'm on page 12. And line 10, the consolidation will provide enhancements listed above.
Yeah, so it goes back to with the testimony on page 10 and 11.
Okay. So clarity and transparency, although there's no issue with clarity and transparency now, right?
Again, we feel like it will add clarity, I mean, between the groups.
To customers.
Yes.
But there's no issue with the clarity or transparency of the individual tariffs now to a customer.
Again, if you look at it specifically, if you're looking at the specific tariff, no. But if they have questions and when they go to the websites and are researching Chesapeake Utilities or and so forth, then going down and looking at Sandpiper or Elkton and stuff, this would streamline it so that they would only see the one tariff for all units. And we do believe that will add clarity.
And then if the corporate realignment leads to a future rate consolidation, then capital and other costs can be spread across a larger customer base.
That is correct.
So that's a contingent enhancement or benefit, right? Hasn't happened yet.
That's correct.
Moving to a common tariff, common company name, and unified rate classes has the potential to generate efficiency gains, cost savings, and improved customer experience. And I think you came up with an amount for that, correct?
Yeah, we took a high-level estimate. But you're correct, they have not been recognized.
And then, bottom of page 11, line 14, additionally, CUC would incur some one-time additional costs to initially effectuate the consolidation, including updating procedures, computer systems, logos, and delivering customer communications on the changes. Do you have an estimate of those one-time additional costs?
No, I do not have that with me.
Do you know if it's more or less than the estimated savings?
Yes, in the first year it would be.
But then you're going to save money on legal bills, right? On page 12.
Associated with the future rate cases and stuff of that nature?
Yes.
Yep.
So then at line 6 on page 12, you were asked, will the proposed consolidation negatively impact the reliability, quality of gas service, or quality of customer service that customers currently receive from the companies? Is that a factor the commission should weigh in determining whether to approve a proposed consolidation?
I mean, that was up to we were supplying the information kind of based on what was requested in phase one and stuff. And again,
Do you think that's relevant?
I think service is always relevant.
Reliability, quality of gas service, quality of customer service. Do you think those are all relevant to the Commission's consideration of this case?
I'm not sure if it is for this case, but I think they're all relevant items.
And how will the newly consolidated company better serve customers?
Again, streamline items and single tariff.
But service, actually providing the service, gas.
Again, less confusion with logos in the field and stuff. When different employees, especially specialized employees, come on site and stuff of that nature, they all will have the same branded.
So you were here with us in phase one, correct?
Yes, Your Honor.
Did the Commission have the ability to simply deny the phase one application?
Commission, yes.
So the Commission didn't need to give the company the opportunity to come back in a phase two, right? The company could have been forced to file a new application, isn't that correct?
I assume so.
Do you know of a prior case analogous to this one, in which the Commission, instead of denying an application, allowed a company to come back in a phase two to determine just and reasonable rates, but in that phase two, the rates were determined to include amounts as if the rates had not gone into effect in phase one?
Excuse me? Oh, I'm sorry.
Do you know of a case, prior case, Commission case, analogous to this one, in which instead of denying an application, the Commission allowed a company to come back in a phase two to determine just and reasonable rates? And in that phase two, the rates that were determined included amounts as if the rates had gone into effect in phase one.
I am personally not. But I know there's other true-up mechanisms and stuff in other cases, but I'm not sure if that's what you're getting at.
I would like to know if there are any cases analogous to this one.
I mean,
Not that you know.
not that I'm aware of, but again, I'm not the one researching those items.
Any redirect?
Very briefly, Your Honor, if I could. Mr. Red, are you aware of Columbia Gas's service territory? Columbia Gas is another local distribution company in the state of Maryland.
Yes, I am.
Are you aware that it serves in Hagerstown, Maryland, which is in Washington County?
Yes.
And you're aware that it also serves in Cumberland, Maryland, in Allegheny County, 65 miles away?
Yes, that's correct.
Okay, and are they a consolidated company as far as you know?
Yes.
Okay. Thank you. No, nothing further, Your Honor.
Thank you.
Thank you. Mr. Evergnam is here, Your Honor. The companies would like to call Matthew Evergnam to the stand.
Raise your right hand. Do you solemnly affirm, under penalties of perjury, that the statements made in this matter today are the truth, the whole truth, and nothing but the truth?
I do.
Please state your name, spell your first and last name, and give us your business address.
It's Matthew Everingham, Matthew Everngam. Business address is 500 Energy Lane, Dover, Delaware.
Your Honor, Mr. Evergnam is available for cross-examination.
So in the application, the company's estimated an unbilled and uncollected revenue amount of $1,077,182 through February 1, 2025, which they propose to recover over 4 years to lessen the impact to customers. The application stated this translates to a proposed annual revenue requirement of $269,296, and the companies proposed to correct any difference based on the actual rate effective date by adjusting its PGA and transportation service balancing rates accordingly. Familiar with that testimony or that?
Yes, Your Honor.
Okay. So the companies had proposed to collect the additional amount by adjusting the PGA and transportation service balancing rates. How would that work?
If there was, let's say, a $100,000 under-earning or under-recovery in that period, you would look at the total volumes recovered through the GSR and the total volumes recovered through the balancing rate, divide those by the $100,000, and that would get you a per-therm rate that you could adjust by, or a per CCF, depending on how you were billing.
But it would be done through the PGA?
That was a proposal that the company had put out there.
The company never amended the Phase 2 application to change this proposal, correct?
That's correct.
And the method you just spoke of, the unbilled and uncollected amount can only be estimated, correct?
That is correct, Your Honor, yes.
And that's why Exhibit 2 to your direct shows projected numbers.
Yes, Your Honor.
I'm sorry, forecasted.
I'm sorry, which, I believe the answer is yes, but just so
Exhibit
to make sure
2
we look at the right one.
to your direct, it's very small.
Yes, Your Honor.
But starting in October of 2024, above that it says forecast.
Yes, Your Honor.
So the numbers are only forecasted.
Correct. They're forecasted based on the projected amount of margin that you see recovered during particular months during the year.
Which is why the amount you calculated was an estimate.
That is correct, Your Honor. It's based on the revenues that we have in Phase 1 and how we looked at the overall revenue recovery. But yes, it is an estimate because you never know what it's going to exactly be until you have actual volumes.
Have you ever been involved in a case in which there was a phasing in of rates?
I've been involved in a case where there was a phasing down of rates in the Sandpiper rate case from 2015. A little different, but there were steps, Your Honor.
But never a phasing in?
That is correct, yes. Not that I can recall, at least.
Well, when you phased down in Sandpiper, you didn't create a regulatory liability, did you?
No, there was no regulatory liability. The phase down was based on the decrease in risk based on the lowering of the propane customers that you had on the system and transitioning them to natural gas.
Okay. So you don't know how a phase-in of rates typically occurs?
You mean if there's a revenue deferral?
Yes.
I've not been involved in a case that specifically has that, no.
So you're not aware of whether the deferred amount is put into a regulatory asset?
I know we had not proposed a.
Not my question.
Oh, no, Your Honor.
You did provide an answer
Sorry,
to
I actually think I do know the answer to that.
which question you're answering.
Your question on whether deferred rates would go into a regulatory asset. We have that in our revenue normalization mechanism where you have deferred recovery. That does not go into an asset that has any carrying charges to it. It's similar, Your Honor.
Right, because I asked for more information on the table on page 7 of the settlement agreement. I can do the math. I understand that there were no carrying costs in the amounts shown in that table, but I was asking whether there was implicit in the settlement carrying costs,
They were not.
similar to what CUC believes was implicit in order number 93111,
Can you remind me which order was 9311?
phase 1.
Oh, the phase 1 order? Yes.
Did you review witness Taylor's testimony in this case?
I have read it, but I do not have it in front of me, Your Honor.
Because as I understand witness Taylor's testimony, typically a utility would accrue a carrying charge to be recovered in the future on the portions not collected immediately.
Okay.
You don't recall that part of his testimony?
I recall that part of his testimony. I don't recall that that was specific to the company or just in general.
That was in
the
general.
statement
I think it's in
yes.
general. Well, it was why I think the company was not proposing to phase in Elkton Gas's rates initially.
Okay.
So you're saying, regardless of what happens in general, the company's in rebuttal when responding to staff witness Evans' proposal to phase in Elkton Gas's rate increase, never calculated carrying costs on the deferred amount.
We did not anticipate carrying costs on the deferred amount, Your Honor.
Because
I do not believe that's part of the settlement, or it's not.
so CUC is willing to forego any carrying costs on the deferred recovery of Elkton Gas's rate increase as part of the
Yes, Your Honor.
settlement.
That's what I'm saying.
On page 5 of your settlement testimony, you state, through settlement negotiations, the parties agreed that the companies were unable to recover approximately $1,649,540 of revenue from the October 1, 2024 to April 1, 2025, which is the estimated in-service date for Phase 2 rates. Under the proposed settlement, the companies will recover this revenue requirement in a rider over a period of 4 years at $412,385 per year. This rider will be applied to all rate classes and will be removed after 4 years. The figure of $1,649,540 is still approximate, correct?
Yes, Your Honor.
What happens if that amount is too high?
If that amount is too high, Your Honor could order a true-up in the rider.
Could order a true-up?
Well,
Is there a mechanism in place now?
there's not a mechanism in place now, Your Honor.
And to your knowledge, no one in this case would be reviewing it to see?
To my knowledge, no. Whether it should be more than that or less than that, it was a settled amount.
What would happen if the rates went into effect before April 1st, 2025?
As it currently is, the settled number would be the 1.649540.
Are you aware that pursuant to the Phase 1 order, rates in this case were suspended 180 days from December 7th, 2024 or until June 6th, 2025?
I don't have that specifically directly in front of me.
Would you believe me?
I would believe you, yes, I would.
So what happens if the commission doesn't issue a final order in this phase 2 until June 6th?
Well, then theoretically, that under recovery would be greater than the $1.65 million.
And what would happen?
The $1.65 million is still the amount that we have in the settlement, and there's no mechanism to change that, greater or lesser.
What's the difference between the collection of the deferred portion of the revenue requirement associated with a phase-in of Elkton Gas's residential rates and the proposed collection of unbilled and unrecovered revenue from phase 1?
The difference between the unbilled and uncollected revenue from phase 1 would be the difference in the revenue that was the $2.6 million that was approved from October 1st until the April 1st. The Elkton would be a separate piece where we were not increasing the Elkton residential and small commercial rates by $400,000 over the first year. That would be deferred for a 3-year period for recovery after the step up in rates reached the full amounts, Your Honor.
Is there conceptually a difference?
There's conceptually a difference, yes. Elkton, you would know the 400 number more exactly, I would say, because we don't know the exact date of the April 1st, 2025 implementation. Very similar conceptually, but slight differences.
Pursuant to the settlement agreement, companies are to submit quarterly notification updates to staff and OPC regarding CIS functionality, any ongoing unresolved CIS metering and billing issues, and the date the CIS customer portal becomes operational, including a description of portal functionality and any additional expenditures incurred to make the portal operational. What's the relevance of any additional expenditures to make the portal operational?
Just informational, Your Honor. There's nothing attached to rates.
So regardless of any additional expenditures that might be required in the next base rate case, the 20-year amortization amount is already set, right, at $896,806?
The period is set. The dollar amount there, I believe, would just shows what it would be for the costs that are incurred to that point. But additional costs that would be incurred would still, with any depreciation or amortization, still be depreciated over the 20-year period.
So what is the $896,806?
That's the revenue requirement for the costs incurred for the system to be functional as of now. That does not incur additional costs for additional functionality.
So it's your testimony that Chesapeake's going to add to the regulatory asset?
The asset itself, as with any investment, you would add. The company will not be recovering on any additional dollars until it came before the commission in a subsequent case.
But you're going to add costs to it?
Just like we add costs for mains and services, and we add costs for our billing systems on a yearly basis as you're working on them in a normal course of business. It's really a normal investment.
So the $896,806 is going to increase?
That is not going to increase in the revenue requirement. No, that is set. I could expand on that a little bit more if you'd like.
Yeah, you're going to need to, because
Yep.
I'm
Yeah,
looking at
so-
your Exhibit 1.
If you,
to
so
your
there
direct.
would be two things that would happen with a customer information system, and honestly similar to any investment we have. There's an amortization over the years which draws down the investment and pays back that investment. There's also additional investments made into the investment. So the next time the company comes before the commission in a case, if it has invested more dollars than it is amortized, the dollars make the system more functional and give the customers additional benefits, but that would then slightly increase the dollar amount that you would come for your revenue requirement when you come in for your case. If
Okay.
you've invested an amount that your amortization outstrips that, the 890-some thousand would be less the next time the company comes in for a case because it's being amortized and paid for by the customers. It's a balance of investment versus amortization period.
It was my understanding that the regulatory asset was going to no longer be in place once this amount was set. So I'm not sure that,
Correct. The asset itself was for non-capitalizable costs, and those costs have been generally spent. Additional investments in the system are normally capitalizable costs, and so while they're part of the asset, while they're part of the asset in the asset meaning the customer information system, the regulatory asset is just a piece of the investment costs of that, which was approved in the previous hearings.
but the regulatory asset will no longer be in place.
The regulatory asset will be in place, but amortizing down. But the regular investments going forward would be in the traditional plant on the asset. And when I say the asset, I apologize because that's confusing between the regulatory asset and the asset itself, the asset of the CIS system. But the recovery from the customers of the 890-some thousand in here does not increase as we continue to invest in the asset and provide additional functionality.
So in the next base rate case, the company is going to come in and seek whatever non-capitalized expenses are in the test year for that case, right?
It would be looked at in that case specifically, and it would be looked at that time.
Do you have your rebuttal in front of you?
I can pull that up. Yes, Your Honor. I have that.
So at page 5, you refer to witness Atoyan's rebuttal.
Mhm.
You say, see witness Atoyan's rebuttal testimony, exhibit SVA-R10 for the calculation.
Oh, at the very bottom. Yes, Your Honor.
That's staff's estimated one-year revenue under collection for Elkton phase-in rate design. That exhibit shows the calculation of under-recovery, so the phase-in will be for Elkton Gas's residential customers only?
No, that was the staff's phase-in was all customers, I believe. It was residential and commercial. I do not have staff's testimony in front of me, but I believe that was for residential and commercial was their proposal.
Okay, I'm at, you don't have SVA-R10, do you?
No, can I grab that, Your Honor?
Yes. Mr. Quinn is going to get that for you.
Thank you. Yes, Your Honor, I have that now.
Okay. So, I assumed we were talking about the numbers in red.
Yes, Your Honor.
Okay, so at the bottom, residential's 410, 309?
Yes.
Hence your testimony, the companies, once consolidated, the consolidated company, will recover the revenue requirement associated with the $400,000 of unbilled and uncollected revenue from phasing in the Elkton gas rate increase. Isn't that the $400,000?
I'm sorry, Your Honor, are we on my rebuttal or are we on my settlement testimony?
We should be in your rebuttal.
Yes. In the rebuttal, I talk about witness Thomas's proposal for the $800,000, and then we talk about, then my last paragraph in the rebuttal, we discuss limiting it to the $400,000 number, which would be the
Which you say
residential
comes
classes
from-
only.
Right, which you say comes from this exhibit, right? Isn't that
Yes,
what
that
you
is correct, yes.
said? Okay,
That does point to it. in
that's
that
why we
exhibit.
pulled up this exhibit,
Yes, Your Honor.
and this exhibit shows the residential classes at 410,309, correct?
Yes, it does, Your Honor.
So that's why you said 400,000.
Yes, Your Honor. It was not exact, but approximately, yes.
Okay. So my question is, why, if we are phasing in only residential customers,
Mhm.
why are GS1 customers going to pay a portion of the residential phase-in?
So this was the proposal in the rebuttal testimony. In our settlement, it was just, the parties agreed that it would be residential and the GS1.
So you're going to
So,
not only charge the GS1 customers, you're also going to defer
phase it in-
GS1?
yes, Your Honor, yes. In the settlement, it would be phasing in the residential and the GS1. And it was the residential and the GS1 were the customer classes that saw the largest increases. That's where we ended up settling on. And we ended up settling on an amount of $400,000.
Even though, going back to SVA R10, that would get you closer to 500,000.
Yes, through negotiations, the parties all reached the $400,000, and it was independent of the SVA R10 specific calculation, Your Honor.
You just decided that 400,000 was a good amount to defer.
That was through negotiations. That's where the parties reached.
It doesn't provide any particular benefit to ratepayers, right? There's
it
no,
do-
it's not a reduction in,
It's a phasing in of the increase, Your Honor, but in the end of the day, the dollars are still recovered, Your Honor, yes. The benefit, I believe, being the delay of the rate increase, the phasing in of that, except for instead of doing it all at once.
was there concern about rate shock to the GS1 customers?
But yes, Your Honor, there was, the GS1s, I believe, had the next highest increase after residential service 1 and residential service 2. So there was a thought of delaying the rate increase to the GS1s and providing them some of the rate shock delay as well.
I don't remember reading that. I remember reading about the residential.
I don't know if we specifically stated that, Your Honor. I do know in Witness Atoyan's schedules in her settlement testimony, it does lay out the increase deferral for 1, 2, and residential 1, 2, and GS 1.
Any redirect, Mr. Quinn?
Just one point of clarification, if I could, Your Honor. Mr. Evergnam, I believe Judge Lawrence asked you about the proposal in the Phase 2 application to recover the unbilled, uncollected revenue from the Phase 1 rate. But I believe in the settlement, did we change that recovery proposal?
Can we not lead the witness, please?
what's our settlement proposal to recover the unbilled and uncollected? Is it different?
The settlement proposal is different from the application proposal, yes.
In what way?
The settlement proposal is a straight dollar amount recovered from the customers on a volumetric basis.
Thank you, Your Honor. Nothing
you.
further.
Thank you, Your Honor.
Your Honor, the remainder of the company's witnesses are virtual, and I can name them and give their topics if you'd like, or if you just, whenever you're ready, if you'd like, I can
Kim Estrada?
introduce Kim Estrada. Yep, Kim Estrada's on the Zoom, Your Honor, and she's a witness related to the company's customer information system. The company would like to call Kim Estrada to the stand virtually.
Do you think we'll see her at some point?
Kim, are you there? You need to turn your camera on, Miss Estrada. The building's going to go dark.
All right, test.
Oh.
Can we hear her yet? She's not. Miss Estrada, can you say something? Test, say something. Can you get her to talk?
Yeah.
Oh, it looks like she's talking now. Yep, you're the youngest here.
I'm just wondering if you click the, like in the bottom, or you control it from right, if you click the bottom right in the speaker icon, I just want to hear if like you can actually hear anything, right? So just like click the bar somewhere. Okay. What's the bottom left join audio? We have.
Sorry about that.
No?
That's a delay.
Yeah, no, I think it's us speaking and then being
That's a delay.
Yeah, no, I think it's us speaking and then being. Just hit no.
All right. Gee. Oh, got him?
Like, I really can't tell if it's her problem or our problem. Well, I'm sure it's our problem. Probably. But the thing is, like, the speaker's gonna be working, so if she's saying stuff, I feel like we should be able to hear it.
We're gonna make her sing?
I don't know.
All right, we can't hear the virtual witness, and we don't know why.
I don't know if it's her problem or not.
You can't hear before or never?
Oh, no, she's the first virtual witness.
Did she turn on the mic? She didn't turn on the mic.
Well, she's here.
Exactly. Okay.
Like, there's a box around her seemingly that she's speaking, but I can't
Right?
hear her. And
Yeah.
the rest of the sound seems to be working, so I don't. Can someone else try? You get somebody else to try?
Yeah. Let somebody else try that, you know.
Like Joey or John?
Okay.
Somebody. See if it's like the whole thing. Just her.
You, it look like her mic is okay.
Yeah, I mean, I don't know.
Hey, Joey, can you turn on your camera and try to talk? No, can't hear Kim.
Can you contact anybody else?
Yeah,
He is.
Miss Ball is,
Can they hear Kim on the call? Can they hear it on their end? Just curious.
there's Joey.
It's like stuff I was trying to say stuff. I think it's the thing.
Oh, nobody. None of those.
We're not getting any sound from this.
Oh.
But check this, the speaker is seems to be working.
Where's the sound?
Feed some audio, right?
Audio?
They click the chevron and go to audio settings, right? They said they can hear each other on their end.
Oh, they can hear each other.
They can call. Why can't we either? The call per se. Scroll down.
The eye thing has to be on, and the witness's mic has to. Is the eye thing on?
The eye thing.
The eye thing, the eyeball. That's on, right?
This one?
No, this thing, this thing.
Oh, that one.
The eye thing has to be on, and the witness mic has to be in front of it. I got the witness mic.
There's a light on it.
Yeah,
I know.
We test the sound from there.
Yeah.
You see that? We test the sound from here.
What if you just hit join audio? It says join audio. That. Yeah. Just join. Stop testing it. Just join it. Stop testing.
He wants you to just
Just
do
join.
that, and then hit
Yeah.
join.
Recording in progress.
Okay, now I can hear John. Yeah, okay. Tell John to stop whatever music. Can she hear us?
Ms. Estrada, can you hear us?
What's our?
Can you hear us?
I just got a message that says.
Testing 1, 2, 3.
Okay,
Okay.
yeah.
Yeah.
Yes, I can hear.
Yes, I can hear you.
Thank you. Thank you.
Ms. Estrada, can you hear me? Ms. Estrada, can you hear me? It's Brian Quinn.
Yes, I can.
Okay. I'd like to attest that witness Estrada is in a room alone without any other person in the room, and she's available for cross-examination when ready, Your Honor, as soon as she gets sworn, I suppose.
Can you raise your right hand? Ms. Estrada, can you raise your, thank you. I think there's a delay. Do you swear or affirm under penalties of perjury the testimony you're about to give in this proceeding will be the truth, the whole truth,
Yes,
and nothing but the
I'm
truth?
raising it. Yes, there seems to be a long delay.
Yeah. Do you swear or affirm under the penalties of perjury the testimony you're about to give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
So, your direct testimony at page 6, you stated, starting at line 2, over the next several years, the schedule for improvements and enhancements includes, and then you list a number of items: a customer portal, a customer notification and preference management system, additional self-service functionality opportunities. Do you, can you expand upon the time frame for those over the next several years?
Yes, the customer portal will be in service by the end of 2025, and the other items of functionality will be phased in over the next several years. We have the list of items we would like to do. They have not yet been prioritized in the order that they will be delivered.
So other than the customer portal, which will be in place at the end of 2025, the other enhancements might extend, say, beyond 4 years from now?
Yes, I believe that the majority of the functionality will be implemented within the next 4 years, but it could go longer than 4 years.
To your knowledge, is the company likely to wait to make certain improvements and enhancements given the 4-year stay-out provision of the settlement?
If I understand the question, we do not plan on waiting 4 years to implement new functionality.
Looking at your settlement testimony starting on page 7, you indicate that the parties have agreed to various items in a communication plan. The First item is e-blast emails communicating the rate increase and impact on the customer's bill. My question is, approximately what percentage of your customers does the e-blast emails, or do the e-blast emails reach?
I would need to look at the exact number for Maryland to give you that percentage. As a whole, for all of Chesapeake, we have about 30 to 40% of our customer emails.
And the third item is bill messages. A note will get printed on the bill indicating that there has been a rate increase. With the website, the customer can visit for more information. How difficult is a bill message?
It is not difficult.
And then the direct mail communicating the rate increase and impact, that's going to go to everyone or just the customers for whom you don't have email addresses?
We would expect that that would go to all customers to ensure that they receive the communication.
How costly is that?
It is just under $1 per customer.
Thank you. For the record, I want to say that we had some issues publishing notices of the pre-hearing conferences in the customer's service territories, and I find it interesting that the company never proposed e-blast emails, bill messages, or direct mail to notify customers of the case or the public hearings. I'll just state that for the record. Thank you, Mrs. Stroud. I assume you don't have any redirect.
That's correct, Your Honor, no redirect.
Thank you. 10 minutes, she'll be gone.
How rude, she didn't say you're welcome.
We have Mr. Taylor, I guess?
Thank you.
John Taylor, can you turn on your camera? Your Honor, while Mr. Taylor's turning his camera on, I want to attest that he's in a room alone with no other individual in the room with him. And Mr. Taylor's available for cross-examination.
Yes, that's correct.
Mr. Taylor, can you raise your right hand, please? Do you swear or affirm under penalties of perjury the testimony you're about to give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do.
I want to talk to you about page 33 of your direct testimony. If you could please read lines 3 through 17.
Did you want me to read those aloud?
Yes, please. Into the record.
Okay. As cited in the Phase 1 order, staff witness Thomas testified. Oh man, I'm getting a. Sorry, I got an echo here that troublesome. So give me a second. I'm going to try this. Can you hear me?
Yes.
As cited in Phase 1 order, staff witness Thomas testified that alternatives exist to protect Elkton gas customers from a large rate increase, such as phasing in rate increases over time. Witness Thomas does not expand on the process of incorporating such phased approach, and consequences of such a proposal may arise that can lead to a greater revenue increase in the future and an unfair cost distribution to the future customers. In order to incorporate the phased-in approach, CUC would be required to defer any uncollected revenue and create a regulatory asset to be collected throughout a certain period. This approach may lead to a snowball effect by delaying the problem and pushing it further into the future. Furthermore, this approach could exacerbate cost recovery challenges, cash flow constraints, and regulatory delays. While phasing in rate increases may seem like an attractive short-term solution, it introduces long-term risks such as increased costs, financial instability, regulatory uncertainty, and unfair cost distribution. A more immediate, balanced, and mitigated approach, as proposed by the company, can reduce bill impacts, avoid the risk of phasing in rate changes, and support a more sustainable financial strategy.
So it is your testimony that in order to phase in a rate increase, CUC would have to create a regulatory asset of the deferred uncollected revenue, correct?
At the time of writing this direct testimony, that was my perspective, but as the facts evolved in the proceeding, I don't think that that is a necessary outcome of what's being proposed.
But that would be the typical outcome of what was proposed, correct? The snowball effect that you referred to?
Oftentimes, regulatory assets are created, so yes.
Well, it's your testimony. You said the snowball effect by delaying the problem is that a regulatory asset would earn a return, correct? In a typical case?
No, I don't think that's my testimony, Your Honor.
What's the snowball effect?
Well, the snowball effect is, I think, what I was alluding to, which is that you would have to continue to assess and implement new rate changes over time, and potentially delaying the increases that customers would be seeing from just simply doing it in one step instead of a phase-in. So it's just a balance of either do you get it all done in day one with the rate change, or do you have to do this over time?
And doing it over time would be a snowball effect?
That's how I use the term in my direct testimony, Your Honor. I'm not sure it's the most accurate representation of what would occur in a snowball effect, typically being that something starts small and grows larger. If the regulatory asset or the deferral has no carrying cost on it, as in the settlement proposal, then there is no snowball. It's not an amount that grows over time.
But in a typical case where there's a phase-in of rates and deferred revenue requirement is placed in a regulatory asset, it would earn a return, correct? That's where you would get a snowball effect? In a typical case, not this case.
Your Honor, I don't know what the typical case is, so I'm not sure if a regulatory
Are you
asset
familiar
in the
with any
context of
cases in which,
phasing in rates in a jurisdiction in which there's not a phase-in process that's commonly created. I'm not sure that those regulatory assets would have a carrying cost, but in a circumstance in which you are phasing in with a regulatory asset that has carrying cost on top of it, then that's where the term snowball effect is most relevant.
have you been involved in any cases in which there was a phasing in of rates?
I'm thinking back. Give me a second. Not in the context of a base rate change.
Witness Atoyan testified that the company is prepared to provide any additional bill impact summaries if requested. Do you know if exhibits SVA-R5, R6, and R7 are intended to show the same thing as the bill impacts for the proposed settlement as were reflected in JDT-1 to your Phase 1 settlement testimony?
I'll have to look at those exhibits. Can you mention them again so I can write down what I'm looking at?
JDT-1 to your settlement testimony in Phase 1.
And comparing that to SVA
R5, 6, and 7.
Yes, to answer your question, those both appear to be the monthly bill impacts associated with the proposed rates and I guess the initial Phase 1 settlement versus the company's rebuttal position in this phase of the proceeding.
Do you happen to know why Sandpiper has 3 residential rate classes currently? One with the lowest use having less than 87 CCF?
I do not know what the history of those rates.
That wasn't important to your analysis.
No, Your Honor, it's not necessary for me to understand exactly the nature of why rates were set up in the first place.
Any redirect?
No, thank you, Your Honor.
Thank you. Witness Toyan. Actually, let's take a 10-minute recess.
Thank you, Your Honor.
We're going to take 10 minutes,
Then we'll come back.
and then we'll come right back. Thank you.
not doing anything. So.
We're still off the record, right, Your Honor?
Yeah, we don't have. I mean, we are streaming, and everyone can hear what we say. But we're
Your
not
Honor,
on the record.
I was told by our witnesses that they're hearing you through the YouTube, but not through the Zoom. And that could be, perhaps you don't have your microphone on, I don't know. But that's was thought to be the reason for delay with Kim, Miss Estrada.
Zoom's over there somewhere.
Yeah. One, two, three. One, two, three.
I think that one actually came across on Zoom.
Yeah, can you hear us?
Yes.
Okay.
What'd you do?
I changed the audio microphone to the whatever this conference cam thing is.
I think you got a minute. Right?
I didn't know you were tech support, man.
All right, we're back on the record. Yeah, we're back on. Can you hear me? Okay.
Yeah, I can hear you.
Excellent. Mr. Quinn, you want to tell us about your next witness?
Yes, Your Honor, the companies would like to call Svetlana Atoyan to the stand, and I'd like to attest that Miss Atoyan is in a room alone with no other person with her while she's on the Zoom.
Satoyan, can you please raise your right hand? Do you swear or affirm under penalties of perjury the testimony you're about to give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do.
Your Honor, witness available for cross.
Mr. Toyan, are you familiar with the executed settlement agreement in this case?
In regards to rate design issues, yes, I am.
Page 7 of the settlement agreement indicates that the parties agreed to a rate rider applicable to all rate classes that will be in effect for 4 years.
Mm-hmm.
If I look at Exhibit 2 to the settlement, are you familiar with that document?
No. I do not have I do not have it in front of me, the exhibits to the settlement, unfortunately.
Can we get her that document? Because it has to do with rate design, so I think you...
Ms. Atoyan, it's
Mhm.
Exhibit 2, the settlement rates. exhibit that was a one-page exhibit that I can email you now. Mr. Toyne, I just emailed you the entire settlement agreement, and there's 3 attachments to that email. 1 is my cover letter, 2 is the actual settlement agreement, and 3 are the 2 exhibits to the settlement agreement. And
Okay.
The judge
Waiting
asked,
for them.
Yep,
Yeah.
and the judge is asking about Exhibit 2 to the settlement agreement. Just taking a minute, Your Honor. Mr. Toyne, the last page is the Exhibit 2, the last page to the exhibit's attachment.
I see it now. I have it in front of me.
Okay, thank you.
Exhibit 2 settlement rates.
Yep.
Yes.
Yes, I do have it.
So the first table is for Maryland Division, correct?
Correct.
And over to the right is the unbilled and uncollected rider, correct?
Correct.
And then there's a line for years 1 to 4.
Mm-hmm.
So if the parties agreed to a rate rider applicable to all rate classes that will be in effect for 4 years, why is there only a rate shown for the residential service classes and general service 1?
So since this particular unbilled and uncollected is related to customers that received an increase, I would probably correct you there. That's unbilled and uncollected is limited to the classes that actually received an increase. So those were for Maryland, those were only 3 classes, residential and general service. So that's the main scope of allocation of unbilled and uncollected. There was some movements in revenues for GS2 and 3, but those were just to adjust and align the rates. those unbilled and uncollected did not relate to other movements and revenues for GS2 and 3. So basically, unbilled and uncollected will be collected from rate classes that receive an increase in this case.
Can you show me from phase 1 somewhere GS 2, 3, 4, and the high load not receiving a rate increase? Where would I find that?
From phase 1?
Yes. Isn't that what you just said? They must not have received a rate increase. That's why they're not getting any portion of the unbilled and uncollected rider.
Yeah, so let's look at the let me pull up Mr. Taylor's testimony.
Settlement testimony in phase 1?
No, not phase 1. Phase 2. It's all these agreements were within the phase 2, not
Isn't
phase
the
1.
unbilled and uncollected rider collecting an alleged amount owed from phase 1?
Right, but that's the phase 1 revenue increase and allocation apportionment among customer classes is determined in phase 2. So in phase 1, we determined that Maryland entity will receive, if I'm not mistaken, some amount, like $1 million or, let's see. So that determination of revenue apportionment, so Maryland, $1.3 million was decided in phase 1, right? And then phase 2, we filed to apportion that $1.3 million increase. And $1.3 million increase in phase 2 was apportioned among residential 1, 2, and general service 1. So that's the main allocation of revenue for this class.
And I thought I understood you to say that was because GS 2, 3, and 4, and so on must not have received a rate increase.
Correct.
In phase 1. So then I asked, where could I verify that GS 2, 3, and 4 didn't receive a rate increase in phase 1?
I probably misspoke about phase 1. Phase 1, as a main determination of what classes receive an increase, it was determined in phase 2. And in phase 2, I was trying to look up testimony filed by Mr. Taylor to compare what increases staff proposed and what we agreed to in a settlement, which would limit them to show increase to only residential and general service 1 classes. And I was gonna try to see if I can point you to that place. So if you look at John Taylor's testimony, settlement testimony, page 11.
Phase 2?
Phase 2.
Okay.
So as you see, the settlement agreement increases and changes are shown in column called settlement agreement, 1, 2, 3, 4, 5th column. And this is like residential 1 is getting 78,000, residential 2 885, and general service 331. So all of these three numbers comprised of 1.3 million 096, sum into that number. The rest of the movements in GS classes were done on a net zero impact between those GS classes to balance out some rates, to allow high load customers to have discounted rates and GS4 class to have the lowest rate. So all these like little movements that you're seeing in GS2, 3, 4, and high load classes net to zero, while the kind of the core allocation happened between residential 1, 2, and GS1. And that's what the percentages increases in the last column show, what the settlement was agreed to. So based on that, the main drivers for the revenue change of unbilled and uncollected will reside between RS1, 2, and GS1 classes. That's why unbilled and uncollected was only applied to those three classes.
And you said that was because it must have been that in phase 1, GS2, 3, 4, and so on didn't receive a rate increase. Isn't that what you said?
I did not mean to impose anything that relates to phase 1 results reflected in this table. Phase 1, it's probably I misspoke or I apologize.
Okay. Well,
phase 1 has little anything to do with the revenue apportionment in phase 2. Revenue apportionment fully determined in phase 2 and agreed and proposed as phase 2 proceeding. So when I say they did not receive an increase, all the general service classes, I mean that in the settlement agreement column, we really didn't give them any increases.
I understand that. Are you saying that it's possible that in phase 1, there would have been revenue apportioned to GS2, 3, and 4, but in the settlement it was decided that they wouldn't get any of the deferred amount?
No, I did not say that. That's phase 1 determines the total revenue increase, not the apportionment. As you can see,
wasn't there an apportionment proposed in phase 1? Was there not an apportionment proposed?
There was, but different scenario was addressed in phase 1. Different increases, different considerations, and it's hard to compare it to anything that's been done in a phase 1 from the revenue apportionment perspective.
Then I don't know how I would ever determine that the proposed revenue apportionment for the alleged unbilled and uncollected amount is fair.
Well, let's discuss why those unbilled and uncollected are occurring. Those are occurring because the rates had to go into effect at
I meant
as to
between the classes.
That's what I mean. If the unbilled and uncollected are caused by the rate implementation delay, that would have been affected only residential 1, 2, and general 1 class.
Why?
Because those are the only classes that receive an increase. The unbilled and uncollected is driven by the uncollected portion of revenue that would have been contributed by only these classes.
The GS2, 3, and 4 would not have contributed any income starting back to October 1?
No, they would not contribute to the increase. They do contribute to total revenue, but the increases are only caused or would have been applied to only these 3 classes.
Why is that? Because that's what you decided in phase 2.
Right, because they are the classes that do not contribute to their cost to serve. Based on the cost of service studies, it was determined that all other classes contribute more than their fair share of the cost, and these 3 classes were not contributing enough. So that's why staff recommended, and we agreed to only limit increases to these classes. You can see that our CUC's proposed changes and staff's proposed changes were fairly aligned because of that cost of service results.
Do you happen to have witness Taylor's settlement testimony in phase one? Phase one? Does she not have that?
I have it. I have electronic version. I'm pulling it up. Okay, I'm here.
So I'm looking at Exhibit JDT-1. I'm on page 38 of 42.
One page, what page?
38 of 42.
Okay.
What does that page tell us?
Maryland high load factor, bill impact. This page tells you what bill impact will high load customers see that will transition to from high load to general service 1 class. So that's the first kind of set of tables, 2 tables. And then the second table will tell you what will high load factor, customers receiving high load factor services under current rate will have the impact if they transition to general service 2 class. So basically, just since the proposed changes in customer structure, the customers may end up in general service 1 class or general service 2 class, and what the percentage bill impact would be for those classes.
And for some portion of the customers who are moving to general service 2, it appears as though they would receive a bill impact between 7 and 9% increase. Correct?
Yes.
And the following page,
Yeah, it's
GS
the same.
service 2 high load, small increases, right?
Yeah, so those customers receiving currently high load factor services that will transition to general service to high load, they will receive lesser increase, yes.
Okay, and then now I'm on page 40 of 42, and the second table appears to show customers going from Maryland high-load factor service to Maryland general service 2, and it appears to me, would be projected to receive bill impact increases between 7 and 8%. Is that correct?
Yeah, these are transportation services, so yeah, that's correct. To clarify, the first tables you were referring to, it's the same combination of transitioning from high-load to general service 1 and 2, but this page 40 shows the transportation services, which the only difference, frankly, between those schedules would be the consumption level. So, that's what it tells you. It shows the different range of impacts depending on the consumption levels.
And similarly, page 41 of 42, for customers going from Maryland high-load factor service to Maryland general service 3, looks like they would have a bill impact of a 4% increase, right?
That's correct.
If we go back to Exhibit 2 to the settlement, the middle table is for Elkton Gas, correct?
Correct.
And that shows an amount in years 2 through 4 for all classes, correct?
Correct.
Why does it show an amount for all classes?
Because for Elkton, if you look at John Taylor's testimony, settlement testimony in phase 2, table 4, you'll see that the 1.7 million that we agreed on, total increase for Elkton, all classes receive an increase, not only residential 1, 2, and general service 1. So similarly, we use the same revenue apportionment percentages to reallocate it unbilled and uncollected. It's the same conceptual approach that we just talked about Maryland. It follows the agreed revenue increases among classes. That's why the unbilled and uncollected are also applying to all classes, because they do contribute to that unbilled and uncollected, because they had to see those increases at the time when the increase was approved.
Looking at your rebuttal testimony, bottom of page 10, you talk about staff's proposal to phase in.
Yes.
You said, under staff's proposal, the smallest residential customer will observe around 47% increase to their total bill increase, or 61% of the base rate bill over the 2-year period. In contrast, CUC's proposal mitigates the impact by capping the one-time increase at 30% on the total bill basis, offering a lower overall increase than staff. That was your testimony?
Yes.
What was staff's response to that?
I'm not certain that we received a response to staff to this rebuttal. Maybe I'm wrong, but if you attorneys can help me out here, but I haven't read any responses from staff regarding this particular issue I posed in the rebuttal.
Is your testimony still accurate? Could the impact still be mitigated as CUC proposed?
Well, that was the position in the rebuttal.
Right, and now there's a slightly different amount of revenue requirement, correct?
Can you repeat that question?
I think the company is taking a position that the total revenue requirement has increased.
Total revenue requirement increase is the same under all positions, whether it's staff's or ours. In the rebuttal testimony, we mitigated impacts further, and that was the position in rebuttal. But
so is it your testimony that you can still mitigate the impact of the rate increases by capping the one-time increase at 30% on a total bill basis?
That's my rebuttal position, yes.
Do you believe that that could still be accomplished? Instead of phasing in as proposed in the settlement, is it still your testimony that instead of phasing in, there could be a one-time increase of 30%?
Rate design in general has a range of reasonable outcomes that could consider various aspects and factors, and the positions were displayed by all parties and witnesses, including mine, in the rebuttal, which states that we could have mitigated it differently, and but it doesn't mean that what staff proposed is unreasonable or would
That's not what I asked.
accomplished.
That's
in
not
the
what I
settlement.
asked. I asked whether
My position in rebuttal remains as disclosed and displayed and analyzed. And whether we can go back to my rebuttal position and change the settlement, of course we can. All the things can be accomplished depending on the goals and preferences, I would say. All information is in record, and if the decision made to go back to one of the positions posed by the parties, it's all on the record.
So I'm looking at your exhibit SVA-5R, Bill Impact Maryland. Schedule 1 is Bill Impact Maryland Residential Service. You just walk me through
Right.
what exhibit SVA 5R tells us.
Yeah. So there are 4 tables presented in the attachment, on the first page of it, and it's specifically for residential services. First table shows the rates and bill impact on a current bill that customer under given usage sees every month throughout the year, and it assumes certain PGA level of rate as well. So it's total bill basis. Then in the next table is proposed rate changes if we do not, if the proposed rate structure is not approved. So under similar revenue increases among customer classes, what the rate would be for residential service if rate structure changes is not approved. So that's what the second table is. The header says increased rates, existing structure. And then the third table is if we increase, so if you remember from Mr. Taylor's testimony, we took a kind of principled approach, increasing rates and revenue distribution. So if we would increase residential class rates under proposed structure, but we don't propose any reallocation of revenues to mitigate bill impacts and such. So that would be the third table. And the fourth one is after we consider some of the rate design issue and redistribution of revenue among classes, that's what the impact is under our proposal. And the fourth is what the proposal would be under what the staff's proposal is. So it's basically tells you, summarizes on one page what different bill impacts would be under different considerations.
Okay, so then in the next page, when we're talking about residential service 2, those customers will see a bill decrease in the summer months?
Yeah, $1.
And a couple more pages down when we get to Maryland medium volume service, those customers will also see a rate decrease in the summer months. Correct?
Yes, that's
up to
correct.
10%?
Yeah.
And then if we have to go a few more pages till we get to Elkton Gas residential, and then they have an increase all months of the year up to 56%, correct?
Depends on the scenario, but there are different impacts
I'm on
under
page 1
each
of
proposal.
12.
Yes? Which column?
Oh, I went all the way over to the last column, staff's increased rates, proposed structure.
Right, yeah.
Isn't that about where we ended up in the settlement?
About that level, but we agreed on step-in rates, so it's going to be lesser impact year 1 and year 2. So smoothing out the impact on a one-time basis.
Okay. And the company's proposal through some sort of reallocation in the column next to it looks like average increase of 30%, maybe as high as 35%.
Right. Yeah, a little bit less.
But for the commercial classes for Elkton, I see rate increases for all of those. Is that right?
Yeah, well,
Until we get to
there will
large
be
volume.
some reallocation. So yeah, obviously there will be some increases on commercial sides under company's proposal will be higher than under staff's proposal.
Okay. Until we get to, looks like, page 8 of 12 is Elkton, large volume industrial, and now we have some pretty large decreases, correct?
Correct. You know, it's important to know that as you can see, they currently are under large volume industrial classes transitioning to general service 1, meaning that even under current rate design, they're not, you know, supposed to be on that class. So even though I prepared the analysis to demonstrate the transition, because based on the record, there are some classes that will be transitioning to this new general service 1. However, even under companies' current tariff provisions, they would be reclassifying these customers either way because they're not really at the level to be in a large volume industrial class, I believe. Oh no, I'm sorry, I misspoke. This is Elkton, Elkton, not Maryland. I don't believe Elkton has those provisions for classes to be reclassified. They only have one large volume. So yeah, I misspoke. This is, regardless, they will be transitioning to GS1 as they, you know, smaller use customers with the impact.
Less than 10,000 therms.
Right.
And they'll have a bill decrease of up to 62%. Under staff's proposal. Actually,
Yeah,
even
different
under your
months.
proposal.
Yeah, under different months, on average, it's 24%. Yeah. I think it's important to note that these changes are also due to the stride rider that are currently recovering as a fixed rider. You can see that customer charge is currently is really high, and once you reallocate that customer or roll in those riders into base rates, they're being reallocated to be recovered either through customer charge or rate per therm, which contributes on the bill impact to be shown this way because they're not high use customers contributing that fixed amount. And once you know adjust it out, that's why you're seeing some of the decreases on a month-to-month basis because they no longer have that high stride rate.
And on page 9 of 12, under the company's proposal, I guess the fifth column, Elkton mitigated increases proposed structure therms. What's happening there?
In what's happening there?
Well, I see a small increase, and then a small decrease, and then 146% increase, and then a
Yeah.
57 or 67% decrease. So
Yeah.
I'm wondering what is happening.
Yeah, so if you look at the usage column, the very first column on the list, there's some, this is all actual data, Your Honor, and it's linked to, or it's the source of the data is actual usage to be closer to demonstrate how these customers will be impacted. So it's a simple average of the usage of the group of customers, which there probably was some adjustment in July of 23 resulting in negative terms, which probably I should have caught and adjusted out, researched it. But you can see how different the usage throughout the months is for that customer. So when you see such big changes, which are probably driven by customer joining or any other reasons, I mean, I can't attest to that at this moment. But due to these various usage levels, that's why you're seeing these impacts in the bill to be from 1 month, it goes from $300 a month or 4% increase to negative 46 is because of the usage consumption levels.
Then a few more pages down, page 1 of 30, we are at Sandpiper Residential Service 1.
Mm-hmm.
And even under the current structure, Sandpiper Residential customers in the Residential Service 1 class would receive rate decrease every month, correct?
You're looking at the residential.
Yes.
So 2 first pages of it shows the customer. Yeah, I think they're relatively very close. I don't think we've, under all scenarios in Sandpiper that we presented, I don't think there was such a big shift or movements from what the current structure would have been and under the proposed structure. But to answer your question, under current, they will see a small decrease, yes, $4 or 6%. Residential class remaining on residential 1 as it stands right now. But once you start transitioning them to what the company is proposing, there will be some different outcomes, but very, very small changes.
Well,
sorry, my printouts are not well printed. I'm struggling with
residential 1, it's small increases in the proposed.
Mm-hmm.
Then when you get to residential 2,
mm-hmm.
under the proposed, it's all decreasing. Every month of the year is a decrease, average decrease of 10%.
Yes.
Okay. Why are Sandpiper's residential rates for residential service 2 decreasing?
Well, there could be a number of reasons because Let's see.
Isn't it because you're going from,
I think,
they're being transitioned into a new class, and then they're going to receive a rate decrease when that happens?
yeah, I think the way it's presented is that some of the classes that currently in residential 1 class will be transitioning to residential 2, getting a lower volumetric rate, and that could lead to decreases on the consumption level. So it kind of balances out the consumption level and the classes currently residing in residential 1 that should be in residential 2. Kind of, yeah, I would agree with you that it's because of this transitioning. That could lead to decreases.
So some customers in Sandpiper's service territory, some residential customers will see a bill decrease, and others will see a bill increase. Is that correct?
Well, this is true to probably all areas, because if you are high consumer and
We're not talking about high consumers, are we?
yeah, well,
We're talking about, it
I would-
says
I
88
take-
to 349 CCF.
yeah, to answer your question, yes, some customers in Sandpiper territories, some residential customers will see increase and some decrease.
And that's all just going to be explained on their bill.
I cannot attest to that.
And then just to finish up, Sandpiper's commercial customers looks like they're receiving a bill decrease as well, right?
Because of the transitioning, yes, there will be some decreases and increases depending on the consumption levels and how they transition to new structures. There will be, either increases or decreases on average or on a monthly basis.
Well, I only saw, for commercial classes, I only saw decreases. I'm looking for where there's an increase, Sandpiper commercial customers.
Let me point you to that.
I mean, I see a couple 0%, but then other than that, I see negative. I don't see a single increase for a Sandpiper commercial customer.
I'm trying to locate it. The page number 6, Sandpiper General Service 3. So page 27 of 30 schedule, SVA R7, Schedule 6. Trying to locate it. It's page, yeah, it's the 2020 page, 27. You'll see that general service 2 customers transitioning from commercial service 3 to general service 2, they will see an increase under our proposal, under either staff's or the company's proposal.
What's the middle columns that say difference?
It's Ocean City.
Oh.
We ran their bill impact separately. I may be willing to reproduce the schedules to easily display the impacts because I think it's printed. It's printed way it's hard to follow which classes will see decreases and increases, but I can attest that there will be some increases in general service, Sandpiper, depending on where they're gonna end up in which rate schedule.
Any redirect?
No, thank you, Your Honor.
Who do we have left?
We have Ms. Ball.
I didn't think her testimony,
She
wasn't
did not
joint?
file settlement testimony. She just filed joint rebuttal,
Yeah, I think we've covered that.
and that's everybody. That's Bill O'Brien is the other name on the
Right.
co-counsel.
Okay. So I think at this point it makes sense to break for lunch.
Your Honor,
Yeah.
before we break, I know we spent a lot of time talking about settlement testimony just recently, but we only entered into the record Phase 2 joint applicants 1 through 13. Would it be appropriate for me to move joint applicants 14 through 18, Phase 2 testimony?
Well, in the event that the settlement is not approved, as I understand the settlement agreement, the parties have the right to withdraw from it, in which case I don't know that OPC and staff would agree to stipulate to the settlement testimony coming into evidence.
Well, that's what I'm asking. I'm moving it into, I'm asking you that.
I think you need to ask. I don't think I'm going to be able to approve this every single term of the settlement agreement as drafted, in which case you have the right to withdraw from the settlement. In that case, you have the ability to object to the settlement testimony coming into evidence. Do you do so? You want to think about it? We can take lunch. You can let me know.
Sure.
You might want to think about it, Mr. Schuh.
Okay.
Thank you.
Thank you.
All right, we'll be back at 12:10. I'm sorry, 1:10.
Okay. Thank you. Hey, Ryan, can we leave stuff in the room? Yeah. Okay. Right. Okay.
We're back on the record in case number 9722, Phase 2, in the matter of the application of Chesapeake Utilities Corporation, Sandpiper Energy, Inc., and Elkton Gas Company for a general increase in their natural gas rates and for approval of certain other charges to their natural gas tariffs. Is Mr. Myers going to be joining us? Oh, he's here. Fantastic.
Is here.
Okay. Are we up to OPC's witnesses?
Yes, Your Honor. Or should we address the?
We had a open issue about the exhibits.
It's not on. You have to push the button. Yeah.
Your Honor, did we make a decision on the on moving the testimony in support of the settlement in filed by the company? I think before the break, I just asked if.
Yeah, I didn't know if staff and OPC wanted to make that decision already, if they want to wait to the end of the hearing.
Yeah, OPC doesn't object to the entrance of the settlement
Are you
testimony.
withdrawing from the settlement agreement?
I don't know at this time.
But either, regardless of whether you decide to withdraw from the settlement agreement, you don't object to the settlement testimony coming in.
Correct.
Staff?
Same, what he said. Thank
Okay.
you.
In that case, exhibits JAP 14 through 18 are admitted.
Thank you.
Now we're up to OPC. Did you want to do your other exhibits first?
Yes, Your Honor. If I could mark.
You can make your way up, sir.
If I could mark the direct testimony of Greg R. Meyer, or direct Phase 2 testimony of Greg R. Meyer as OPC exhibit, or exhibit OPC P2-1. The direct testimony of Colin T. Fitzhenry, Phase 2 testimony of Colin T. Fitzhenry as OPC P2-2. The Phase 2 rebuttal testimony of Colin T. Fitzhenry as OPC P2-3.
Those will be marked.
Yes. And I guess, should I have, I could, the direct testimony of Jerome D., Phase 2 testimony of Jerome D. Mirswa as OPC P2-4.
So marked.
The Phase 2 rebuttal testimony of Jerome D. Mirswa as OPC P2-5.
So marked.
And the Phase 2 rebuttal testimony of Jerome D. Mirswa as OPC P2-6.
So marked.
And may I move that OPC exhibits P2, 1, 2, and 3 be entered? Or I guess all of them,
Any
unless you'd like
objections?
to wait.
No objection, Your Honor.
No objections, thank you.
OPC P2 exhibits 1, 2, and 3 are admitted into the record.
Okay, and that OPC calls Mr. Jerome D. Mirswa to the stand.
Please raise your right hand. Do you solemnly affirm under penalties of perjury that statements made in this matter today are the truth, the whole truth, and nothing but the truth?
I do.
Please state your name, spell your first and last name, and give us your business address.
My name is Jerome D. Mirswa. Jerome is spelled Jerome. Last name Mirswa is Mierzwa. And my business address is 10480 Little Patuxent Parkway, Suite 300, Columbia, Maryland, 21044.
Mr. Mirswa, do you have before you your Phase 2 direct, rebuttal, and surrebuttal testimonies?
I do.
Marked as 4, 5, and 6, respectively. Were all these documents prepared by you or under your supervision and direction?
Yes, they were.
Do you have any corrections to make to your testimony at this time?
Not that I'm aware of.
If you were asked the same questions today under oath, would your answers be the same?
They would be.
Do you adopt the Phase 2 direct, rebuttal, and surrebuttal testimonies as your sworn testimony in this matter?
I do.
Your Honor, I move that OPC's 4, 5 exhibits P2, 4, 5, and 6 be admitted.
Hearing no objection, those will also be admitted.
Thank you, and the witness is available for examination.
you have an understanding of what's driving Elkton gas rates up at a higher increase than the other companies?
I'm sorry, did you say higher increases than other companies?
Yes.
No, I looked at the cost. My responsibility is cost allocation rate design. I don't look at the actual revenue requirement aspect of the proceeding, or what's often referred to as cost of service. I look to the allocation of a cost of service amount, not the actual cost of service.
Have you ever been involved in a case where there was a phasing in of rates?
Not such as this one. Typically, in those cases that I am involved in, where there's it's a multi-year rate plan where utility files rates for the first phase or year one, and rates for year one are based on that revenue requirement for year one, and then there's a future test year where they put in additional projections of plant investment, and in the second year, and how many ever phases there are, there's 2, 3 sometimes, where the revenue requirement is based on anticipated plant and service and other expense increases.
But not a case in which the base rates were phased in to try to avoid rate shock?
No, I've never seen that in my 35 years. I'm sorry, phased in to avoid rate shock. I've never seen them phases. I've often seen things done to avoid rate shock.
But not a phasing in of rates?
Right.
What have you seen to avoid rate shock?
Oh, just allocations to customer classes which are reduced to or mitigated to avoid rate shock.
In your direct testimony on page 7 indicates that you did not oppose the company's proposal to assign or transfer all the franchises held by the Maryland Division and Sandpiper to Elkton, or the company's proposal to unify the 3 separate tariffs into one. And then, following your response that you did not oppose that, you quote or directly cite to the testimony of Christopher Redd, correct?
That's correct.
What factors do you think the commission should look at in determining whether a proposed consolidation should be approved?
Well, I think overall savings would be one, and I believe the company mentions things, uniformity in rates would tend to mitigate any customer questions and or confusion.
Mr. Redd used the phrase public convenience and necessity. Familiar with that?
I've heard the term. I'm not an attorney, so I'm not sure I know what that means.
Can you explain why the allocation of the alleged uncollected amount from October 1, as reflected in Exhibit 2 to this settlement agreement, results in just and reasonable rates for all classes, for all customers of all?
I haven't looked at the settlement. I was not aware that was filed until Saturday afternoon and was preparing for this proceeding.
Any redirect, Mr. Shu?
None, Your Honor.
Thank you.
Thank you. Do you want to, I'll call our witnesses or the ones?
It's your case.
Okay. We'll call Evan Thomas to the stand, please. Steph? And we ask that he be sworn in, please.
Raise your right hand. Do you solemnly affirm under penalties of perjury that the statements made in this matter today are the truth, the whole truth, and nothing but the truth?
I do.
Please state your name, spell your first and last name, and give us your business address.
My name is Evan Thomas. That's EvanThomas, and my business address is 6 St. Paul Street, Baltimore, Maryland 21202.
Mr. Thomas, what is your job title with the PSC?
I'm a regulatory economist in the Telecommunications, Gas, and Water Division.
Mr. Thomas, do you have in front of you the direct Thomas of Evan Thomas, filed on January 23rd, 2025, for case 9722, phase 2?
I do.
Mr. Thomas, at this time, do you have any corrections, additions, or deletions to that direct testimony?
No.
Staff requests that Your Honor mark the direct testimony of Evan Thomas as staff exhibit number P2-1.
So marked.
Mr. Thomas, did you author this testimony?
Yes.
Was it prepared by you or under your supervision?
Yes.
If I were to ask you each of these questions now, as you're under oath, would your answers be the same?
Yes.
Mr. Thomas, do you adopt this testimony as your sworn testimony in this case?
Yes.
Your Honor, staff requests that staff exhibit P2-1 be admitted into evidence.
So admitted.
Mr. Thomas, do you have in front of you the surrebuttal testimony of Evan Thomas, filed on February 26, 2025, for case 9722, phase 2?
Yes.
Mr. Thomas, at this time, do you have any corrections, additions, or deletions?
No.
Your Honor, staff requests that you mark the surrebuttal testimony of Evan Thomas as staff exhibit number P2-3.
So marked.
Mr. Thomas, did you author this testimony?
Yes.
Was it prepared by you or under your supervision?
Yes.
If I were to ask you each of these questions now, as you're under oath, would your answers be the same?
Yes.
Mr. Thomas, do you adopt this testimony as your sworn testimony in this case?
Yes.
Your Honor, staff requests that that you admit staff exhibit number P2-3 into evidence.
So admitted.
And the witness is available for questions. Thank you.
Mr. Thomas,
Good afternoon.
did you either know or heard the testimony about how Elkton Gas has experienced the most recent rate increase in 2019
Yes, I heard.
out of the three companies that we're talking about today?
I am aware of that, yes.
Okay. Can you explain to me why it is then that Elkton Gas, whose rates were adjusted most recently, needs a large increase again, a larger increase than the other two companies?
I cannot explain that.
How does utilizing a rider to collect the unbilled and uncollected revenue prevent the companies from collecting more or less than the $269,000 over 4 years, as you testified in your direct testimony at page 31?
So my main concern in my direct testimony was that the unbilled and uncollected revenue from phase 1, as the companies proposed in phase 2, was collected in base rates. And so if the companies don't or were to not file a rate case after 4 years, which is the set collection period for that revenue, it would still be built into the base rate, and they would continue to collect that amount. And so I pulled it out of base rates and treated it as the separate rider.
Have you ever been involved in a case before where there was a phasing in of rates?
Not as a witness.
But you're aware of one?
I'm aware of some. I know there was the Easton rate case last summer that was for both gas and electricity, and my understanding is the electricity side of the case, the rates were phased in.
Over how long?
I'm not sure exactly, either 2 or 3 years, that was my understanding.
Do you know why?
I believe bill impacts, to manage bill impacts.
Do you agree with witness Atoyan that Chesapeake's proposal would have provided for a maximum one-time increase to Elkton Gas customers, but that with the phased-in approach, they will see a much greater overall increase?
I do not agree with that. the phased-in approach makes the increase more gradual and is better for residential and the GS1 customers.
How do you explain her testimony?
Where she says that,
Yes.
I believe that was in her rebuttal.
Yes. At page 10.
I'm having trouble finding it, but if you could just. Yeah. All right, thank you. Okay, I don't believe this is true, and I believe there is a mix-up. The mix-up that I think could have occurred here is that there was a comparison made between total bill impacts and distribution rate impacts. In my testimony, in my direct testimony and my rebuttal testimony, I have bill impact tables, and the numbers shown there are distribution rate impacts only and do not include a commodity portion of the bill. And the bill impacts that the companies have presented, I believe in all of their testimony in this proceeding, have included the commodity, and so that would lead to different numbers. That is exactly. And the reason I say that is that the numbers don't really match what witness Atoyan is saying. In my direct testimony for phase 2, the very first exhibit, I presented just like a spreadsheet of all of the different rates. So the company, they provided rates with the existing customer classes. They provided rates with the proposed customer classes. And under the proposed customer classes, they had 2 approaches. So the companies really presented, I think it was 3 sets of rates, although they had one that they favored. And then I showed essentially the same thing, but I just had 1 set for existing and 1 set for proposed. And if you look, I'm just remembering this off the top of my head, but I think it really speaks to the point. If you look at Elkton on the company's, what they're calling the reallocated approach, I believe the volumetric per therm rate is about 70 cents. I could be remembering that.
Should I look at the
At
settlement tables? Or
No, no. So from my direct testimony,
I'm looking at your table 36 for Elkton.
Yeah.
That's the revenue allocation.
yes. So if you go to my very first exhibit, I called it ET1-phase 2. This is just a presentation of all the various rates, just in one spot. So this would be, though, my position in direct testimony and the company's position in direct testimony. So obviously there were minor changes to the revenue requirement, I believe in rebuttal, which would lead to small changes. But if you see here, I don't know, let me know when you're looking at this table.
Oh, I'm on ET-1 phase 2.
Exactly. Okay. So there's kind of 2 rows, if you will. The top row is titled CUC developed rates. The bottom row is staff developed rates.
Yes.
In the top row, the rightmost table, or technically it's 3 tables, but the right column, if you will, there's a entry for each entity. So it goes Maryland Division, Elkton, and Sandpiper. If you look at Elkton, RS2, which is the second entry, the volumetric rate is about 71.5 cents per therm. Do you see that?
I do.
If you go down to my proposed rates under the proposed rate classes, just to compare apples to apples, Elkton, Res 2, I show the phase-in, so I show year 1, year 2, but if we just look at year 2, you can see my volumetric rate is just under 64 cents. And so there's no way that their bill impacts should be less than mine.
And that is just looking at the total rate, not even including the phase-in. So in year one, you can see that the Elkton customers under the phase-in would experience roughly 50 cents per therm.
So there's not, though, an exhibit. If I wanted to compare the final numbers with Chesapeake's non-phased-in proposal against your phased-in proposal, there wouldn't be an exhibit to look at.
That puts them side by side. The company may have. I didn't. I'll say that much.
And it wouldn't have to be. I don't think there's a huge change between. Well, maybe there was between rebuttal and the settlement, but.
Right. Okay, I have, I think the closest to what you're looking for is in Witness Otoyan's surrebuttal. This is exhibit SVA-S5, and it is the bill impacts for Elkton. Oh, I'm sorry. This is actually in the settlement testimony.
Okay. I
Yeah.
didn't see the rebuttal. Okay. I have it
My fault,
on
yeah.
settlement. And, I'm sorry, where'd it go?
So SVA-S5.
It's very small. Got it.
Okay. And so there's three parts to this table. Okay. Well, there's more than that, but three I want to focus on. So looking at the top row, the table's there. You can see there's settlement agreement, CUC's phase 2 rebuttal, and STAP's phase 2. Okay. If we focus on CUC's phase 2 rebuttal and STAF's phase 2, and we look at the second entry, which is Res 2, Elkton,
Yes.
you can see CUC's is 29%, and right next to that is STAF's is 24%. And that is because my volumetric rate is lower, and so the bill impacts are lower. These percentages don't necessarily match those in my testimony because I understand these to be total bill impact. So commodity is included in this, whereas the bill impacts that I present are distribution only. But this comparison here is apples to apples, the 29 versus the 24.
And then the boxes underneath year 1 and then year 2 through 4 show the total?
Okay, so the year 1 box is showing the impact of the, I think it's showing the impact with the phase 1 unbilled and uncollected. Do you see that column? It says unbilled and uncollected.
No.
It is
Oh,
the fourth column. Yeah.
Yeah. Yes. Okay.
And so I think that this is showing the year 1 impacts with that included, whereas the tables above are not showing the rider included, just the base rates, if you will. That's my understanding.
Would it be both portions of the rider?
No, so that's why there's year 1 and then years 2 through 4. For year 1, the rider is only collecting the phase 1 deferred revenue.
And 2 through 4 would have both.
Exactly. And so if you look in the year 2 through 4 table, okay. So
It's an additional 16%, right?
in addition to just the base rates, correct. But if you look, okay, in year 2 through 4, that bottom table, the 4th column is titled Unbilled and Uncollected.
Right.
Just take the first entry, Res 1. You see that it's 2.1.
Yes.
If we compare the 1.2 above,
Okay.
Well, anyways, the point I want to make, I think this year 2 through 4 is taking into account both parts of the rider, the phase 1 part and the Elkton phase-in part. I guess this doesn't, the explanation I just gave there doesn't really make that point, but the fact that it's higher leads to that.
What's the last column reference? What is that? Difference of what?
That is the difference in the current monthly bill, which is in the second column, okay? And the what I understand to be the total bill, which is the third to the right column. So this would be your total bill impacts. This is the distribution rate increase as well as the rider.
Okay, so in year 1, Elkton Gas Res 1 customers are going to see a 37% increase. Is that right?
Based on this table, yes.
And then in years 2 through 4, Elkton Gas Res 1 customers are going to see an additional 16%?
No, I think this table is misleading because this is showing really what you need is a year 1, a year 2, and then a year 3, I guess, because I think for year 2, from year 1 to year 2, you're having the phase-in, and so base distribution rates are also increasing. And so in years 3 and 4, the base distribution rates are not increasing because it's a 2-year phase-in. And so these bill impacts really are just for, this bottom table is really just year 2. But I think it's titled year 2 through 4 because the rider is applicable for years 2 through 4. And so I think there's just a little bit of a mismatch here.
If there wasn't an attempt to collect some deferred amount, would you still believe a phase-in is necessary?
Without the deferred amount?
Yes.
Yes. The Elkton, if you're looking at just base distribution, based on my allocation from Phase 2 Direct and Surrebuttal, the Elkton Res 1, Res 2, and GS1 would receive a 60% base distribution revenue increase.
Where's that? I thought that already had the deferred in it.
No, that's just the that's just the regular allocation without the deferred.
Where's that?
That is in Witness Taylor's rebuttal. He has tables that present this very nicely.
Tables, not exhibits.
I believe they're tables, yes. Yes, so it looks like table 3, which is on page 9 of his rebuttal for phase 2. It's the top table. It has staff's recommended revenue change and CUC's proposed revenue change. And so under staff's, you can see that Res 1, Res 2, and GS1 would receive an increase of 59.1%.
But the amount being allocated, isn't it, if you go up to table 1, isn't it the total revenue increase of 1.7 million.
Sorry, I was looking at table 2.
That's all
So, no, well, table 1 has the phase 1 revenue increase. It has the phase 2 revenue requirement, and then it's just summing those. So this does not have
right.
any
Doesn't have the other.
doesn't have any deferred revenue in it.
Okay, so that's why you're saying, looking at the 59% increase, even without the additional deferred amount, you would recommend phasing in.
We would, yes.
Do the tables that I attempted to go over with witness Atoyan, with all the decreases to not only commercial classes, but Sandpiper residential classes, all of those make sense to you?
Okay, they do, but I would like to add a couple points of clarification, especially for the non-residential classes, which were the ones with the, at least my understanding, the more.
You can add that if you can explain the residential.
Well, okay, well, so for Sandpiper, the under-earning classes are the residential classes. And so if you look actually in, I just have John Taylor's rebuttal testimony in front of me still. We were looking at table 3, which was Elkton, but if we go down to table 4, which is Sandpiper, it can be seen that under staff's, what he calls staff's recommended revenue change, if you will, he shows it in dollars and percentage terms, that I recommend that residential 1 and residential 2 both receive what comes out to be an 8.6% increase.
I see that.
The reason I allocated the revenue to them is because they are the under-earning classes, and so by allocating them revenue, we move towards parity, which is normal for allocation, which is what you want, and is an attempt to reduce cross-subsidization. But you can see that the key here, though, is that the non-residential classes are receiving no revenue increase because they are over-earning. And the bill impacts that, all right, I'm going to start with the non-residential, then I'll circle back to the residential. But the non-residential, as is seen in this table, are not receiving a revenue increase. The reason that they are primarily negative, at least the bill impacts that you were going over with witness Atoyan, is because of the removal of the system improvement rate, which is a rider. And so that, I don't have it in front of me, but it's a per therm rate that's applied to all consumption. And this is where the whole Ocean City distinction starts to come in, because there's a separate adder for Ocean City specific customers as well. But in the bill impacts that you're going over with witness Atoyan, the system improvement rate was shown in the current bill calculation, but was removed in the proposed bill calculation. And so the system improvement rate, I forget the exact number, but it comes out to roughly 50 cents per therm, which is fairly significant. And so if you were to compute the bill impacts without the system improvement rate, it would come out essentially more similar to kind of Maryland Division's non-residential, where they generally received a slight increase. However, I just want to add that throughout this entire case, I have been including the system improvement rate, just as witness Atoyan did, in addition to the Elkton Stride Rider, because they are currently being charged those. But at the conclusion of this case, they will be removed. And so it's, an attempt to capture the moving parts of the case, I guess. And so to kind of represent what customers would actually experience.
Is there a large amount of stride being moved into the case?
I'm not sure. All I know is that at the conclusion of this case, the surcharge, if you will be removed.
Okay. You said you were going to circle back to why
Yes, okay, so-
Sandpiper's residential rates are going down.
Right. And so part of that is because the SIR is being removed for them as well. But since they're getting a increase, it is less severe, if you will, generally speaking. But essentially it's because of the SIR as well. But it really comes forth in the non-residential because they're not receiving a revenue increase.
Does that comport with your understanding in phase one that the residential customers were the ones that were going to get a rate increase and the commercial classes weren't going to see much? They weren't getting allocated with the revenue?
That is consistent, yes.
Any redirect?
No, thank you, Your Honor.
Thank you.
Staff wishes to call Drew McAuliffe. And we request that he be sworn in. Thank you.
You didn't enter anything in.
I'm sorry, for Evan, we had marked and entered into evidence staff P21 and staff P23.
My recollection was you marked it, but if we didn't enter it, it's entered.
Oh, I asked that they be entered into evidence, and I thought you said yes. I'm sorry.
It's okay.
Yeah,
They're
Evan,
in.
it was staff P21 and staff P2-3.
Yes.
Thank you.
Did you
Thomas
want
Direct
to
and
mark,
Thomas Surabuttle.
Mr. McAuliffe's Surabuttle?
Yes, we'd like to move Mr. McAuliffe's Surabuttle into evidence. I don't know if you want me to lay the foundation. I think.
Did you swear him in?
Please raise your right hand. Do you solemnly affirm under penalties of perjury that the statements made in this matter today are the truth, the whole truth, and nothing but the truth?
I do.
Please state your name, spell your first and last name, and give us your business address.
Drew McAuliffe, DrewMcAuliffe. My business address is 6 St. Paul Street, Baltimore, Maryland, 21202.
Mr. McAuliffe, what is your title at the commission?
I'm the Director of the Electricity Division.
And you have in front of you the Surabuttle testimony of Drew McAuliffe for case 9722, Phase 2, filed on February 26, 2025.
I do.
Mr. McAuliffe, at this time, do you have any additions, deletions, or corrections?
I don't.
Your Honor, staff requests that the Surabuttle testimony of Drew McAuliffe be marked as Staff Exhibit P2-4.
So marked.
Thank you. Mr. McAuliffe, was this testimony prepared by you or under your supervision?
Yes.
And does that mean that you authored the testimony?
Yes.
And Mr. McAuliffe, if I were to ask you each of these questions now, as you're under oath, would your answers be the same?
Yes.
Mr. McAuliffe, do you adopt this testimony as your sworn testimony in this case?
I do.
And Your Honor, staff requests that Staff Exhibit P2-4 be admitted into evidence.
Staff P2-4 is admitted.
And the witness is available for questions. Thank you.
Mr. McAuliffe, are you familiar with a case in which there was phasing in of rates?
Yes. Multiple.
Why don't you tell me about them?
Yeah. Apologize, I don't know many case numbers. I do 4 or 5 cases a year. But yeah, they've always been proposed because of rate shock. There's no other reason I'm aware of to phase in rates. So we had the Easton case last year. Mr. Thomas noted, I believe the Maryland Water Service case this year had a phase in. I know the Maryland Water Service case about 4 years ago had a phase in. Yeah, and I believe there's one or two others I'm aware of. I just can't think of off the top of my head. But yes, it's always for rate shock. And typically, they're more common with the smaller utilities. Obviously, they have smaller customer bases. They typically come in for rate cases on a less frequent basis. So, when you starts to get I'll just say a little nervous when you see 20, 30, 40, and higher distribution-only bill impacts. So then that's when we start thinking of trying to phase in the rates just to ease the burden on customers a bit.
And in those cases that you mentioned where it was done, was the company came in and presumably proved that they were entitled to a revenue increase, and then there was some deferral of a portion of it?
Yes.
So was there an amortization of the deferred portion?
So I believe, I'm not sure about a regulatory asset. I know you were asking about that earlier. I'm not positive if they're always used, but typically it's just, essentially as we proposed in this case, however much you're deferring. There isn't, I guess, a typical case, but at least in some of the cases there is a return component added, which in this case there has not been. So that will occur sometimes. So just say you deferred $500,000 and there's a 5% rate of return, that would add $25,000 to the revenue requirement. In this case, there is no rate of return that's been added. So in staff's opinion, it's a benefit to customers, particularly when you consider the time value of money. $1 today is actually worth less a year from now, so you could actually say it saves customers money actually in the long run. So $1 today is worth, just say, 98 cents next year.
If that, right?
If that, yeah, with inflation, right.
What factors do you think the commission should look at in determining whether to approve a proposed consolidation of 3 companies into one?
It's a great question. I don't know if there's any necessarily rules on the books for this sort of kind of corporate reorganization. But yeah, cost savings, obviously, as we kind of heard earlier, is important in any kind of synergies and all those kind of corporate buzzwords you hear. But yeah, just more efficiently run operation that maybe they can save customers through their billing systems if they combine them, those kind of things. Use similar staff and yeah, just any kind of economies of scale and any efficiency gains, I think, would be a major consideration for the commission.
They're already using the same staff and have the same billing system, right?
I believe so. Yeah, I know their staff is generally the same. But yeah, those are just examples. Just kind of efficiency gains, obviously, would be beneficial to customers. Anywhere they can save a few dollars would be helpful.
The company would have liked to had the same rates for the same rate classes. This is now going to be, everyone's going to have the same rate classifications, but different rates.
Correct.
Does that cause the company any inefficiency?
Excuse me. I think that would be a better question for them, but I don't think it would be terribly difficult for them to, they already know which customers are which with each, I'll just call them subsystems, sub-companies. So I don't think having a couple extra different rates on their books would be terribly difficult. I think that's just a minor IT change.
So witness read used the phrase that the proposed transaction was consistent with the public convenience and necessity. And I've also heard it in a prior commission case, staff took the position that a proposed consolidation was in the public interest. Staff took no position in this case.
Yes, so that exact phrase that witness read is referring to, that makes me think of a CPCN, which I don't think is necessary in this case. But yeah, in the public interest, again, I would just say, yeah, if there's efficiencies, cost savings, things of that nature, considering all, there's no ownership changing.
You said if there are.
taking place.
Did you say?
Well, the company did provide examples. Yes, I just used if as a general statement, but yes, they did provide examples of some savings, and I would imagine as time goes on, there will be more.
Okay, but you submitted rebuttal testimony where all you did was tell me what wasn't applicable, but you didn't come to any conclusion about whether what is before the commission in this case is in the public interest.
Well, we did address in phase one, I believe, the consolidation of the tariffs and the rate classes. I believe that was Dr. Coates. Again, I don't. There's nothing really on the books to describe a corporate reorganization. I guess we don't feel that there's a major corporate change here. They're really just trying to.
So the company wouldn't even need to come to the commission to request
I guess
approval of the consolidation?
I can't really say. I'm not positive. I'm obviously not an attorney. I'm not aware of anything on the books that would require that.
Any redirect?
No, thank you.
Thanks.
Thank you.
Is it staff's position that you don't intend to provide testimony on whether the proposed consolidation in this case is in the public interest?
We can do that.
Well, it's a little late.
Yeah. Oh, yeah. We'd be happy to brief it, Your Honor. Your Honor, can I ask you about Lucy Shea's testimony?
You'd like it admitted?
Yes, ma'am. Thank you.
What would you like it marked?
P2-2.
So marked.
And may I ask you, can I just for good measure, I thought I did, could I ask you if you would admit Evan Thomas's direct testimony, which
That's
was
in.
Oh, did
And
okay.
so is Drew McAuliffe's for rebuttal. And
Thank-
now Lucy Shea's direct is in as well.
Thank you.
So, as I said, I don't think that I can approve every term of the settlement agreement. So what would the parties like to do?
Well, Your Honor, I'd like an opportunity to brief before you make a decision on anything, if that's at all possible.
I guess I'm not certain to the extent to which the more time we spend, it costs ratepayers money. It's my concern. OPC doesn't seem to be concerned about it, but I'm concerned that having already got to March is coming at a cost, some sort of impact. They're going to feel it in the rates because there's at least a proposal to collect back in time.
You're concerned that it's not an impact on customers?
No, that there will be an impact on customers.
Just want to follow Your Honor. In phase one, we've got a final commission order, right? Saying the company was entitled to $2.6 million as of September.
I'm not sure that's what it said. Do you want to pull it up and read it?
It approved a revenue requirement of $2.6 million.
The distribution of which was to be determined in a phase two.
That's correct.
Distribution of that amount was to be determined in a phase two.
The allocation and rate design was to be determined in phase two. But are you saying that the 2.6 wasn't declared a just and reasonable rate as of September 24th, 2023? I mean 2024.
I think I said 91311 before. It's 91411. Oh, no, I was right the first time. 411 is the delegation.
I'm sorry, Honor, I didn't hear you.
I'm trying to find the order from,
The order, it's
here it is.
docket 74, docket entry 74.
Joint application is denied. Joint motion is granted in part and denied in part. Total Phase 1 revenue requirement amount of $2.6 million is approved with the allocation and distribution thereof to be determined in Phase 2.
Yep.
My interpretation of that is that the allocation and distribution of $2.6 million would be determined in a Phase 2, not an additional amount.
Not when?
Not an additional amount.
Yeah, and
My interpretation.
Yeah, and so instead of us going back and forth, Your Honor, if there's something you'd like briefed, I'd like an opportunity to brief before you make a decision. If there's a question that's troubling you that the parties could brief on, I'd like an opportunity to do that.
I believe you had your opportunity to present your case today, by today.
Yep.
So I could get a proposed order out in a couple days that would become a final order a couple weeks after that, which denies your request for a deferred amount in its entirety. That's one thing that could happen. Another thing that could happen is you could brief it. I could think about it, and a proposed order comes out at the end of May, and you have to appeal it to the commission.
Yep. Well, it's kind of hard to react to what your order is going to be when you haven't issued it yet, Your Honor. So if
My order
you're-
is not going to approve the deferred portion.
Okay, and I'm asking if you'd like briefing
No,
on that question.
I would not.
Okay.
You had your opportunity to provide support for that position. I didn't see support from anyone for that position. So now knowing,
I'm not sure I agree with that, but, okay, there's testimony in support of the deferred revenue collection, both by staff and by the company, as to why they thought that was reasonable.
that's not correct. That is not a correct interpretation of staff's testimony. They just said, fine. They didn't provide an analysis of why. And OPC took no position at all. I don't know why. Can't explain it, why OPC would not take position on a rate impactful issue. So, no. Don't need it briefed.
Okay.
You had your chance. So, now knowing that the proposed order will not approve that portion, would you like an order sooner? Or would you like to propose a different settlement?
Your Honor, are you asking me, Your Honor? Well, there's a settlement before you that you just said you're going to rule on before. Might as well, you should rule on that, and then the parties can react as to what the next step will be. I can't speak for the other parties, so I don't know if we're going to reach another settlement or not. But just as you did in Phase 1, you can rule on the settlement as you see fit, and the parties can respond to it, I suppose.
Well, the settlement agreement provided that you could withdraw from it and then litigate. Is that what you want to do?
I'd have to confer with my client, Your Honor. I'm just hearing this for the first time right now. We could get back to you.
Does OPC or staff know if they intend to withdraw from the settlement and litigate the case, or just want to go stick with your settlement position?
Without knowing precisely what the modifications are, I don't know if I can say right now.
Well, witness Thomas explained the rate design in a way that I can understand. What I'm saying would only reduce the overall revenue increase and reduce the rate.
I mean, we would likely, be fine with that.
I don't know that we. Thank you, Your Honor. We do not wish to withdraw from the settlement agreement.
Okay, so it'd just be the companies if they wanted to withdraw. If you want to get back to me on that.
Yeah, Your Honor, you're asking me to withdraw from the settlement
I'm not
agreement.
asking you to withdraw.
Yeah,
I'm
okay.
saying the settlement agreement provided that you could, right?
Yeah, that's true in any case, Your Honor.
Right. So do
Parties
you want to litigate your
Well,
whatever position
I
you
was-
took in rebuttal, or
I was,
even back before that?
that's to be determined, I guess, Your Honor, when you make your decision and we read the reasons why. I don't know if we'll appeal that or not, and that would put the settlement agreement, I guess, back in play. So it's hard for me to answer in the abstract. I do know that I believe the parties agreed to waive, cross, and stipulate on our witnesses today, so I'm not sure what is to go forward in terms of an evidentiary proceeding you'd like, in addition to what we've had today. But
I don't need anything else. It's your right.
Yeah, I'm just reminding the parties of where we were. So with that, I'd have to confer with my client as to what our reaction is going to be to your order, Judge.
Anything else we need to take care of today?
No, thank you.
Okay. I don't want briefs.
I heard you.
I already got gratuitous settlement testimony.
Your Honor, I asked if you would like settlement
I know,
testimony.
and I told you what I wanted, and I got more than what I wanted, but that's fine. It was a
Well-
nice summary of everyone's positions. All right. We're adjourned.
Okay. Thank you, Your Honor.
Thank
Thank you,
you.
Your Honor.